Welcome back to the Fox Robbins Business Show. Great to have you back. This show is all about developing your best business ideas. And we're on episode 3 of 3 episodes with Gene Curry, attorney at law, talking about anything of or pertaining to either starting a business or taking action with an ongoing existing business. From a legal standpoint, and these are 3 good sessions that all business
Very
people ought to
important.
be looking at and paying attention to.
Pay attention is the key.
Pay attention. And I'm the co-host, Bill Fox. The other co-host is none other than the outstanding, the fluorescent
Russian.
Coach Robbins.
How you doing, Bill?
Hi, Coach.
I'm fluorescent today.
And Gene Curry, and thank you again, Gene. This will be part 3 or episode 3 of your presentation. And excuse me, let me get to our first slide. This is going to be heavy-duty stuff because your advice is do carefully consider all financing options. This is great stuff. Go ahead. Let's tell us about this.
So there's a number of ways that you're starting a business or you have an existing business and let's say you want to expand or what. There's a number of ways that you can do that. Your cash, you can put in your own money.
Your own money, right?
Debt, you can borrow from a bank, you can borrow from private parties.
Credit card.
Credit cards, there are businesses that have been funded on credit cards,
Right.
things of that nature. You can get investors, people who are going to put in money in exchange for an ownership interest. Typically, the difference between debt and investment is, if I'm lending you money, Cliff, the debt is, I'm lending you $100,000, you're going to pay me back at this rate, et cetera, and regardless of what happens to the business, I expect to be paid back.
That's why I say debt is cheap, because 5%, 6%, whatever. But it's risky because you want to be paid every month, or
Exactly.
whatever the agreement, right?
Investment, in contrast, relates much more directly to the fortunes of the business,
Right.
or the failures of the business.
You become a risk taker too.
Exactly, and I develop a ownership interest. But if I'm an investor in the business, my rights, if the business goes south and is going to be liquidated, are subordinate to all the creditors. The creditors, if there's assets and cash left over as we're dissolving the business, those go to the creditors first,
Right.
the investors last.
Right.
And then one thing to talk briefly about is crowdfunding, which is a relatively
New kid on the block, right.
phenomenon.
Yeah.
There are several ways that you might crowdfund a business. One of them is, excuse me, I'm going to develop this product, and if you contribute money to that, at the end of the process, you'll get the product.
The product, right? You
Or
pre-buy.
at a lower level, you get a T-shirt.
Right.
I've seen musicians who are raising money for a record album who say, "I'll come and sing at your birthday party
Right.
if you
Yeah.
give me a certain amount of money."
I'll give you one album and I'll come sing
Right.
at your kid's party, right?
There's a lot of flexibility if you're talking about the exchange in the crowdfunding is, I'm putting in money for a product, a service, a T-shirt, what have you. If you're talking about crowdfunding for investment purposes, then there are very strict regulations that apply. That's a very new phenomenon in the last couple of years that this is permissible, but it's only permissible under certain circumstances with broker-dealers or other parties who've registered with the Security and Exchange Commission. And I'm going to talk a little bit about this as we go forward.
Yeah.
But one of the things that you have to be careful about is there are very strict
The
regulations
SEC.
governing how you seek money.
Right.
And you have to be very careful to make sure you comply with them.
Right. They have to be accredited investors, et cetera, right?
So one of the things to think about is consider all money capital as high risk and only put in those funds that you can afford to lose.
Yeah.
So, you know,
play money, so to speak. Yeah.
Yeah.
Extra.
So that, for example, just to use Kurt Schilling's business went badly. And from what I don't know anything about this except what I read in the newspaper.
Yeah, me too.
But what I read in the newspaper was that he had put so much of his own money in that when the business failed, it dramatically affected his lifestyle.
Right.
It really hurt him very seriously.
And his family.
And his family. And I think what you'll see is that certainly most investors are going to want to know, if I'm going to invest in your company, that you've put assets into it yourself,
Right.
that you believe enough in the company.
Right. Sure.
But on the other hand, as a business advisor or an investment advisor, if the person who's running the business can't persuade anybody else, and all of the money is that person's, and that goes on for a significant period of time, that's kind of a red flag.
Yeah, right.
And so if you're putting everything you own into the business, most new businesses do not succeed.
That's right.
And
Yeah.
if you put everything you own to the business and it doesn't succeed, you've got nothing left.
It's huge risk. Yeah, it's a huge risk.
That's a big, Coach, it's a big mortality rate on starting a new business from scratch. Is that the statistics on that are bad, are they not?
They are. It's 80% will fail in 5 years, I believe. 4 out of 5 will fail within 5 years.
That's terrible. That's a huge risk.
Especially if you're it's one thing to put some of your own money in, certainly, hopefully not the important money, like you say, your homesteaded.
By the way, that alluding to the Kurt Schillinger, for a lot of people, he was a famous, highly regarded baseball player. In fact, a pitcher, and was a World Series hero.
Yep.
And whatever. But he used his name, and he got into starting up a company to develop computer games, or a game. I'm not really sure what it was. But getting the game business.
And as I say, I don't know the details. I just know that I remember reading after the business got into trouble that it really had an adverse effect on
his lifestyle.
On his lifestyle.
Absolutely.
And that would be a caution. I throw that out as a cautionary tale, not because I know anything in particular about the circumstances.
Or Kurt Schilling, but yeah.
I don't know. I know very little about it. I did read that. I think that there was a huge what is called a burn rate, Coach.
Yeah.
That they had a lot of money and were spending it that way.
I don't know. That's
it was lack of care and close attention to details.
But I don't know any of that. So
do consult with an attorney before approaching potential investors. Gene, tell us about that.
Well, depending on how much money you want to raise and where you want to raise it, there are restrictions on what information you have to give to potential investors, how many potential investors you can approach, how you can approach those investors. And if you don't know those rules before you begin, you could find yourself in serious trouble because you've exceeded the number, you've approached people in the wrong, you haven't given them, for example, once you make an approach to certain information that, again, the rules vary state to state and even among Securities and Exchange Commission rules, depending on how much money you're raising and who you're raising it from. So if you don't know those rules before you begin, you may inadvertently find yourself already having a law violation and not really having raised very much money at all. So if you're going to start going out and raising money, you really need to do this in advance.
To sit with an attorney and say, now here are the rules.
And it's an attorney who understands investment.
Absolutely. It's critically important.
Limitations on the number or type of investor, and not only that, but how you're talking here about how they can be approached.
That's correct. And so the type of investor, for example, in federal regulations, there's the concept of the accredited investor. The accredited investor has a significant amount of assets, in essence over $1 million. $1
million outside the home, right?
I believe so, yes. And a significant amount of income. And appropriately, the law considers these people better able to take care of themselves than if you're going out to just the average consumers who might or might not be sophisticated about how businesses operate. So there's different rules depending on who you are talking to, and again, how you approach them. matters. Because if the approach may require, depending on that you give a certain type of information at the initial meeting, or a certain type of information within 10 days of the initial meeting, and you really need to know what those rules are.
Right.
One of the things that's really critical and why seeking funds can be an expensive proposition is that in virtually every regulatory regime that governs investment, there's an anti-fraud provision. And the anti-fraud provisions essentially say that if you fail to disclose a material fact or misrepresent a material fact, then you can be in civil or criminal liability. And the definition of material fact is very broad. It is a fact that would affect your decision whether or not to invest.
Right, write a check, yeah.
So you want to, when you're handing out information, you want to make sure that you've thought through very carefully,
Right.
and include anything and address anything that might be a material
Make sure you
issue.
give them a complete prospectus of
Right.
what this thing's all about, and you need an attorney to work with that.
Right.
Now, this one, Gene, is really critical. Do not give ownership to employees or contractors unless justified and documented. And boy, Coach, is this important is to protect the shares and ownership of your company.
I wanted to take in a very high-level executive into a company, and I said to David, I'm thinking about giving him 5% of the company and vetting him over 5 years, 1%. And David said, well, here's your choices, okay? We can draw this up and give him a partnership, or you could just pay him and hire him, or I can give you a gun now. So I paid him, I hired him, I paid him, and thank God I did, because we had trouble 7 years down the road, and he left the company. It would have been a pain in the ankle if he
Well,
had.
Gene, tell us about this, giving ownership to employees or contractors and
Well, there's
justification.
particularly in early stages, you don't
Yeah.
have a lot of money. So there's the
Right.
temptation
Give a piece of the
to
company.
give a piece of the company to people who are providing services, or employees have expectations about, particularly in technology companies, getting some ownership interest in exchange for their services. It's fairly common, a lower salary with the expectation that you're going to get stock down the road. And that can be advantageous, but it can also be a real problem. One of the things you need to be alert to is the fact that if you give ownership interests, that creates stockholder rights,
Right.
and that may affect your ability to make decisions down the road, because you've got to take into account the rights of those shareholders. You have to document things properly. One of the things, there's a very significant, we were talking earlier about securities regulation. There's a very significant difference between a public offering and a private offering.
Right.
And one of the attributes of a private offering is that it cannot be resold except under very limited circumstances. So I, again, had some investors that were looking at a company, and in the due diligence, we found out that they had given stock to employees and contractors who had provided various services without any documentation.
Oh,
So if there's no documentation,
yeah.
there's no restriction on sale because there's nothing in writing, which leaves you open to a charge from the Securities and Exchange Commission that you've been engaging in a public sale of stock,
Right.
which raises huge state and federal legal issues. If you're setting up an employee stock plan, that's what an ESOP is. There are very significant and complex tax and legal issues. You need to have expertise when you set that up.
That's
or you
very
could
complex, yeah.
You could hurt yourself, or you could hurt your employees,
Right.
who may have tax liabilities that come into play even though they actually haven't received any compensation. And that happened, if you remember, when the tech bubble burst. There were a lot of employees who had stock options in the future for which they had very adverse tax consequences. So you need to understand that and make sure that you're doing something that truly is beneficial to both you and the employees.
Right.
One thing to keep in mind is, as you're thinking about bringing people in, there's a temptation, particularly if you don't have much money at the start, to treat people who are truly employees as independent contractors.
1099, yeah.
And if there's a multi-part test that the Massachusetts Attorney General uses, and it involves things like the level of control, things of that nature. But one thing that's really key is, are they really part of your business or not?
Are they doing what the business does, or are they
Exactly.
painting your office?
Right.
That's different.
And if you fail to properly categorize an employee if you categorize an employee as an independent contractor, you can get it. One, the Attorney General's office has made this a priority of enforcement. Two, you can, if the independent contractor, who should be an employee, let's say is driving around, gets on business, company business, gets into a car accident, gets injured, they're supposed to be covered by workers' comp. They're not if they're an employee.
Yeah,
That's going to be a case where you might find the corporate veil being pierced and being sued individually.
that's where they'll pierce the corporate shield,
And
right?
there was a case recently where a guy had been treated as an independent contractor. He was a software coder working for a software company. He was an independent contractor. His contract was terminated. He sued the company for age discrimination because he was replaced by somebody who was younger. He wound up getting paid more than he would have made if he had been an employee. The company had to pay him multiple damages. They were in violation and paid severe fines.
Yeah.
It would have been cheaper in the long run to pay him as
Just
an
pay
employee.
them, even if it's part-time, even if the person's coming in
Exactly.
15, 20 hours a week. They're not independent contractors if they're doing the work that your company does. If you control what they're doing and how they're doing it, they're part-time employees. And you got to pay them as such.
So protect intellectual property in your client's financial information. Let's talk first about intellectual property. Every company has some sort of intellectual property.
Right,
If you've got a brand name, that can be protected by trademark.
right.
The content of your website is protected by copyright.
Copyright.
You may have a formula, as we've talked about in the previous show, or an algorithm,
Or
or
14 spices of Kentucky Fried Chicken,
right, or
right?
whatever.
Yeah.
And you have to take steps to protect that intellectual property, which can include, with respect to copyrights and trademarks, federal registration of copyrights, federal registration of trademarks, state registration of trademarks, controlling who's allowed to use those trademarks with license agreements. If you don't protect your intellectual property, you can lose those trademark rights.
Sure.
With respect to client financial information, there are a wealth of regulatory regimes that govern private information. There's HIPAA on the medical side, but on the financial side, Massachusetts and pretty much every state in the union now has laws that require you to protect a personal information. In Massachusetts, personal information is somebody's name and information that might be used for identity theft, such as a social security number,
Right.
a credit card number,
Right.
a check number.
Yeah.
And if you don't take appropriate steps to protect that, you can be subject to fine, you can be subject to lawsuits where treble damages are
Common, yeah.
are a possible remedy, and investigation by the Attorney General's office.
Could you address something for me, too?
Sure.
Prior art. Just how strong is prior art? In other words, I haven't really copywritten something, or I haven't trademarked with the USPTO, but I'm out there using it in a commercial sense. I mean, how strong is just prior art?
Well, prior art typically applies to patents.
Right.
And it's a judgment call. That's
Yeah.
why you need,
It's
that's a
just
very
weak, yeah.
specialized field.
Yeah.
And you need somebody who's going to be able to evaluate whether the prior art, that's, when people think about, well, I'm going to apply for a patent myself because I think I understand the law.
Yeah.
One of the things that a good patent attorney is going to be able to do for you is assess previously filed patents,
Right.
which contain the prior art,
Right.
and determine whether or not what you're trying to patent is going to be
May
protected.
infringe, yeah. Right.
Your advice here, Gene, the next idea is do research availability of your brand before spending money on marketing.
Yeah, we were going to use the swoosh, I guess, as our, but then we found there was a company already using
There's a
it.
company already using it.
Oh,
I think.
Nike,
Nike or somebody.
Well, and you know, people come into my office and they want to talk about, you know, they've got an idea for a brand for their business. And what you want to do is make sure that there's nobody else out there using something that is significantly close to your brand, not only in the name, but also in other factors, so that there's going to be what is referred to in trademark law as a likelihood of confusion.
Right.
And so, it makes sense to do that research before you spend money. You don't want to have spent $50,000 putting up a website, putting out brochures, running ads,
Right.
and then get a cease and desist letter who says, oh, by the way, we have a federally registered trademark, and your brand name is similar to ours, and if you don't stop using it, we're going to sue you.
Right, and that's a big corporation you got the letter from.
Or a small corporation if they've got a, so there's a number of ways you can do this. You can, you know, simply Google. There's companies that if you're going to spend a significant amount of money, I would typically suggest that a client do a full trademark search, and there are companies that will do that because Google is. You can go to Google. You can go to the the Patent and Trademark website and do a search there, but that doesn't. Those are limited resources. A full trademark search company will have access to lots of different databases, including all of the state trademark databases, so that you know, is there somebody out there that you really have to be worried about?
Right.
And if there is, the easiest thing to do is find a new name.
Now, before
Now,
you've created a
exactly.
a brand,
Take precautions to protect trade secrets and disclosing of inventions.
Right. So that if you are, trade secrets are only valuable if they're secret. So
As long as
you've
nobody
got
else
to
knows.
you've got to take appropriate precautions, and that might include having confidentiality and non-disclosure agreements with your employees and with people with whom you're doing business. But it also means some sort of basic common sense protections. So I had a client who had confidential information regarding marketing plans, pricing, and things of that nature. And an employee left to go work for another company and took that information. And one of the things that helped us in stopping the employee from using that information is that the computer, the database was stored in a drive that was only accessible by a password that key employees had.
Right.
Now, he was one of the key employees and
Right.
used that password against his employer's interest. But if that was open to everybody in the company,
It's open.
we might have had a difficult time in getting the court to enforce the protection of the trade secret.
Right. Actually, one thing about, is there also something, and I know patents aren't your primary thing, but I understand, and I was given this information by a client who came in and said, I have been selling some of these part-time. Now I'm going to go ahead and file a patent. And she said, the fact is that 1 year from the date she commercializes it, she's got a right to file that patent. Is that correct?
It's not from the date of commercialization. You're raising a good point, though. If
Yeah.
you've got an invention
Yeah.
it's from the first public disclosure, not
Okay.
commercial.
Okay.
So you've got to be very careful
Yeah.
if you've got an invention about who you just tell about the
Just
invention.
even telling somebody about it, right?
Exactly. For example, you don't want to you've got an idea for an invention. You don't want to put up a prototype on your website. You want to be careful going to trade shows.
Right.
If you're talking to somebody about potentially working on the invention, you have them sign a non-disclosure agreement.
Non-disclosure, right.
You need to take steps because there is a hard deadline after you make your first public disclosure.
Before you file a patent.
After that, you lose the ability
You
to
lose your
patent.
right to file a patent. Okay, thank you.
Your advice here on this on this slide, Gene, is do consider registration of copyrights and trademarks.
That's right. Copyright and trademark are different, but they have some similarities. Copyright protects the expression of an idea.
Right.
So it's content and
A book, my
book.
website.
It's reduced to a fixed medium of expression.
Right.
So it can also be, you can copyright music through writing the score,
Right.
or you can record a performance. If I were giving this talk in the form of an interpretive dance, the fact that we're putting it on video
Yeah.
means that it's recorded. Whether anybody would watch it, different
Yeah.
question. Trademark is anything that identifies the source of goods or services.
Right.
It can be a name, it can be a logo, the Coca-Cola logo that you see on a can. It can be a sound, the Intel Inside
Right, yeah.
bell noise that you hear
Phrase.
in commercials.
Yep.
It can be colors or patterns, the Burberry pattern, for example.
Right.
And both copyright and trademark rights accrue from first use in commerce.
Right.
So from a purely technical perspective, you get those rights even if you don't register.
Right.
However, there are significant advantages to registration, particularly when it comes to enforcing those rights.
Right.
And you really can't sue to enforce your rights unless you're registered.
Right.
Furthermore, if you do register the marks, you're entitled to more significant
better case.
damages.
Right.
Also, it makes it harder for somebody to say, well, I didn't know that you had these rights, because if you've got federal registration, people are presumed to know whether they actually know or
They're
not.
supposed to know, right.
And so, excuse me, it gives you a lot of advantages.
Okay,
And
very
it's relatively inexpensive. I mean, at the end of the day, it's all of a cost-benefit analysis. but-
Absolutely.
Thank you, Gene. And thank you guys for watching Fox Robbins again. This is episode 3 of 3 episodes with Gene Curry, covering 10 essentials. Well, we've covered a lot of ground here.
Oh, yeah.
And all of it's important. And we thank you for watching. Please feel free to send any comments to foxrobbins@gmail.com. Make those friendly comments, please. And we would like to hear from you. And thank you again for watching the Fox Robbins Business Show. And we'll see you next time.